Good morning. Welcome to Texas Constitutional Carry, Your Questions Answered, Part 2, live here with independent program attorneys for U.S. LawShield, Emily Taylor,
And Richard Hayes.
Richard Hayes, and we are here to answer more of your questions. Keep law-abiding gun owners law-abiding. When you know the law, you're safe, you're legal. It's incredibly important. Richard, do you want to give us a roadmap of what's going on today?
Yes. So thank you all for joining us today. We got so many questions last time. We knew we had to come back and continue the conversation. So just to give you a brief overview of what you can expect to hear in our program today, we're going to go over a brief summary about what we talked about last time, what every constitutional carrier needs to know. Then we're going to come in, do a little bit of cleanup, pick up some questions that we received last time that we think are great questions, need to be answered, and then we're going live to your questions. So we are getting them fed to us live right here. So if you have a question, please submit it. Please, we're all learning from each other. There's going to be some growing pains with Texas constitutional carry. So if you have a question, I bet somebody else has that exact same question. Don't hesitate. Please leave us a comment. We want to answer all your questions. So leave us a comment. Share this video. Break the Facebook algorithm. They hate gun material. Share the video, like it, tag your friend who needs to learn about Texas constitutional carry. But without further ado, let's get started. So recapping our discussion last time, Em, briefly, can you give us just a headline? What is Texas constitutional carry?
Sure. Constitutional carry just means carrying a handgun without a license or permit. And in Texas specifically, that's going to mean carrying it concealed or carrying it openly in a holster. It really is a simple concept. You're going to hear different things: permitless carry, unlicensed carry, constitutional carry. There are debates around the semantics about what means what and what words we should be using. But the general idea is no license or permit required for the first time since Texas has had a penal code to generally carry that handgun in public, concealed or openly in a holster.
Right. And the folks we're talking about are people 21 years of age or older. You don't have to be a Texas resident, okay? But not prohibited under federal law, not prohibited under Texas law to possess firearms and ammunition. So if you're that 21-year-old Texan who's never been arrested, never been in trouble before in your life, you're going to be able to engage in Texas constitutional carry.
Yeah. And if you're wondering about whether or not it applies to you, don't forget, uslawshield.com/takethequiz is actually going to be an eligibility quiz for you. You can go in, get a yes or no answer. If your situation's a little bit more complicated and you're a member of U.S. LawShield, call in, talk to Richard and I, talk to any of the lawyers here in Texas, and we're going to let you know whether or not you qualify for constitutional carry.
Yeah. And then on top of that, again, we're answering the most frequently asked questions. In the description of this video above, there is the guide where we have a full 26-page breakdown that goes into the nuances of Texas constitutional carry. So if you don't get your question answered, please check out the guide. There's a ton of information there. So we've got our 21-year-olds, our law-abiding 21-year-olds carrying concealed any way they want or in a holster. And then just because maybe you've been arrested or you have a criminal conviction doesn't mean that Texas constitutional carry is off the table. Can you talk us through that, Em?
Sure. And before we get to the things that we sort of talked about last time that are really, hard and fast in the statute, we got a question actually, I believe it was yesterday. I got a question just over the phone. Someone who had a deferred adjudication for a felony offense. And it was someone who wanted to be able to constitutional carry, but wasn't sure, and he said, look, I can buy firearms. I'm not a convicted felon, but I know that I'm not eligible for my license to carry because I applied and I got rejected because it's been too long or not long enough since I got off of deferred adjudication probation. But can I constitutional carry? And the answer is yes. If you don't have convictions,
right,
you get that benefit of constitutional carry, even though you might not qualify for your handgun license. So deferred adjudication, that means you're put on probation, but you're not convicted of the underlying offense. You've successfully completed it. You do not have a constitutional carry problem, even though you might not qualify for that license yet. So that's an important thing that I don't think we've discussed live yet, but it's good to know.
Yeah, and really good point, because a lot of people, the DPS likes to do all kinds of crazy things. And what they say is a deferred is a conviction. They define it. They say deferreds are convictions for purposes of licensing. So that confuses a lot of people. It's a really good point. when we're talking about, our clean criminal history people, obviously constitutional carry, engage. But if you have convictions, all we care about is convictions at this point. So we have 5 different convictions you really need to be on the lookout for that would disqualify you for a period of time. Those are assault, deadly conduct, disorderly conduct, discharge as a firearm, disorderly conduct, display a firearm, and terroristic threat. So if you have a conviction for one of those 5 crimes in the previous 5 years, you are not eligible to carry under Texas constitutional carry. If you were to carry, generally out in public, you'd be committing an unlawful carrying of a weapon, which is a Class A misdemeanor, up to a year in jail, up to a $4,000 fine. So we want our law-abiding citizens, our people who are eligible to engage in constitutional carry. But no, folks, if you're not eligible, there's some pretty stiff penalties, so beware.
Yes, and of course, remember, not just those misdemeanor convictions. I mean, that's the really confusing part.
Right.
But of course, we're not expanding Second Amendment rights to people who have lost them because of felony convictions.
Exactly
So
right.
anyone who's got a felony conviction, not only do you not have the right to constitutional carry, you don't have the right to carry generally in public under Texas law. You don't have the right to own ever under federal law.
Right.
So, bear in mind, you need to, and a lot of people are unclear about their criminal history. It is something that can be hard to decipher, especially if it's decades old. You can always call the county from where you got arrested, get those records, ask for the disposition paperwork, see if you were convicted of a felony, see if that was a deferred adjudication. If you need help interpreting it, we're always here to do that as well.
Yes. And so, that kind of encapsulates, remember, can't be prohibited under state law. Those are our folks in Texas Penal Code 4604. Can't be prohibited under federal law, 18 U.S.C. 922. So that's subsection G, I believe. So can't be prohibited under state or federal law. So assuming you're eligible, those are the people we're talking about engaging in Texas constitutional carry. I'm going to jump in because this is a question that I know a lot of people are asking. Chris is asking for some clarification. He says, as an LTC holder, let's see. Josh asks, as an LTC holder, how do the new laws affect me? And while this program, again, is mostly focused on constitutional carriers, it's a great reminder for license holders. If you carry the same way you do today as you did prior to September 1st, you are well within your rights. So that this should not be confusing to license holders. This is the same way you carried the way you carried before. That's how you carry now. Your rights have expanded, in fact, as a license holder. There's a few places like open meetings that now you could carry that maybe you couldn't carry before. But just to put license holders at ease, we're going to keep talking about all these topics. But to put you at ease on the front end, license holders, your rights have just expanded.
Right. And we actually have another related question about a felony dismissal.
Good question.
Yeah. And so when it looks like it's out of state, and so when things happen out of state, you do have to do a little bit of interpretation, and we'll look at things sort of through the eyes of how the DPS would compare it to what goes on in Texas. And it looks like we've got somebody on the Facebook who wants to know if you have a felony dismissed out of New Mexico, and that was going to be 5 years ago, but it was dismissed after probation. So that's what we would refer to here as deferred adjudication. It's called different things in every state. Is she eligible for her LTC? The answer is not yet. It's going to be 10 years at minimum before you're eligible for that LTC after a deferred adjudication dismissal. But are you eligible to constitutional carry? And the answer is yes. So that really, we have opened up the Second Amendment to a lot of people like this woman who's just asked that question because, can you get your license to carry? No, but now you have this option of carrying without a license because you're not a convicted felon. You don't have that 10-year prohibitive waiting period.
And we'll do one more eligibility question and move on. So Marnell asks, if you've been convicted for, let's say a felony 5 years ago, could you carry? No, and it's important to remember, for people who were prohibited from possessing firearms or ammunition or carrying in public generally prior to September 1st, HB 1927, Texas constitutional carry, does not expand the rights of prohibited people. So if you were convicted of a crime, if you were a convicted felon, you'd be prohibited from possessing a firearm out in public under Texas law, and you'd be prohibited from possessing a firearm under federal law everywhere. And on top of that, not only have they not expanded the rights to those folks, they have created almost a second penalty, because right now, let's say, and what we see in our practice, felon maybe shares a vehicle with a spouse. The spouse keeps the gun in the car, and this is a question that came up later, and we'll talk about it. But if they're out driving in their car, they would get charged with felon in possession of a firearm. That's a third-degree felony, serious charge. But now, let's say that felon took the gun out of the car and carries it. They have imposed a second-degree felony for felon carrying a firearm, which is, up to 20 years in the penitentiary with a mandatory minimum of 5 years. So, I mean, it's very, very serious. So this HB 1927, Texas constitutional carry, hasn't expanded the rights for people who aren't otherwise eligible.
Right. And Martell does mention 5 years, and this does get a little confusing, I think, because there is a 5-year period built into Texas law for people who are convicted of felonies. That's 5 years to possess in your home only. And it's 5 years after you've either been convicted, you've been released from incarceration, parole, or probation, whatever's later. Basically, the last time the state of Texas monitored you in any way. 5 years after that, Texas law does say you can possess that firearm only in your home for self-defense, nowhere outside of the home. And of course, federal law says you can never have it. So we've got that little bit of conflict again between Texas law and federal law.
Exactly right. Well, let's move on and let's talk about prohibited places. Where can and cannot a constitutional carrier carry? And we discussed this last time. It's our list of places in 4603. That's our Texas Penal Code, 4603. And license holders, they've had to commit this list to memory. These places are off limits regardless if they post signage, okay, for constitutional carriers. So you need to learn this list. So Texas Penal Code 4603. Now, a note, they haven't updated the law online yet. The Texas Legislative Office and the Texas Legislative Council, they haven't updated the list. So if you want to have a concrete list of the places you can and cannot carry, check out the description of this video. Get the constitutional carry guide. And it breaks down all of those locations. But I'm going to start us off with schools and a location where a school-sponsored activity is taking place. This is an area of confusion, and we've had an overwhelming number of questions about this. And let's talk about the law for license holders, just so that we can contrast what the law is for constitutional carriers. So license holders can carry around schools. They can carry up to the threshold of the building, which the law calls the premises, but they can't carry inside the premises, okay? So that's the law for license holders. But constitutional carriers, we have kind of a different rule because of the Federal Gun-Free School Zones Act. Because a constitutional carrier does not hold a permit or license from the state in which the school zone is located, so in English, Texas school zone, Texas license to carry, they don't have a federal exception. They might meet some other federal exception, but that's the federal exception that license holders meet when they're carrying around the school. And so for our constitutional carriers, unless you fall into one of those other exceptions, like the gun is encased and you're passing through the school zone, or you live within the school zone, or you have property within the school zone, unless you meet one of those federal exceptions, you could be committing a crime under federal law. And so that's why we're not advising constitutional carriers. You wouldn't be allowed to carry around schools. You couldn't go to school pickup and drop off with your handgun, like license holders may be allowed to. So that's an important note. Do you have anything to add to that, Em?
Yeah, just bear in mind that even though it's legal under Texas law, it is illegal under federal law.
Mm-hmm.
It's, again, there are times when the laws conflict, and this is one of them. Constitutional carriers have to deal with this conflict in the law when we talk about being within 1,000 feet of a school, and it's something that constitutional carriers should keep in mind and take very seriously.
And a question we got about this last time was vehicle. Let's say I'm carrying under the authority of a license to carry, and I'm traveling in my vehicle. Can you discuss that a little bit?
Yeah, well, you've got to have your firearms encased. And that's tough, right? I mean, that's the federal exception rule. And a lot of people get this confused, I think, with the federal traveling rule, right? Think, oh, well, I know federal law protects me if my firearm is unloaded, cased, locked in my trunk. And that is true in only a very limited circumstance. We've got federal traveling exceptions, but also, I mean, that's not going to help you at a post office parking lot where federal law says you can't carry.
Right.
It's not, you have to look at those very specific exceptions under federal law and say, firearm encased, I think it's a rack or
a gun rack
or a case. And look at that and make sure that you're following the federal law that applies to your specific situation. Don't get confused between the different exceptions in federal law that exempt you from different sort of different locations, different activities.
And I can hear kind of the collective scream of people watching this right now, because we have lots of people who carry in their vehicle who don't have licenses to carry. And I mean, to put things in perspective, I'm sure this law gets violated millions of times per day. And the person the authority that's enforcing this is the federal government. So there's limited exposure to federal agents enforcing traffic laws around schools in general. So, to put things in perspective, it's the exposure is limited. I haven't heard of it being an issue.
I've never been stopped by the FBI in a school zone.
Right. Yeah. Exactly right. But I mean, we can't, you got to follow the law. You got to follow the law. Let's talk about, do you want to
Why don't we just run through these really quickly? So again, this is your 46.03 list, and it is worth committing these to memory. There are a lot of them, though, so let's just knock them out, and then we'll stop and talk through them as needed. We've got polling places on the day of election and during early voting. We have courts and offices used by the court. That may be the entire courthouse complex. It may not be. But again, if you have specific questions about the courthouse you go to, give us a shout. We'll talk through. It is very gray. We would love to, frankly, we'd love to know more than we do. We're waiting on Attorney General opinions that might help us, but that's been a very long wait. We have racetracks where parimutuel wagering is taking place. That's dog and horse tracks. We've got secured area of airports within 1,000 feet of places of execution designated by TDCJ. We have, and that's on execution day, so I don't keep good track of that, but just put that in your mind as well. Your bars, your professional sporting events, your correctional facilities, your jails, civil commitment facilities, and then some of these vary a little bit. So I guess I'll cut it off there, and we'll start talking a little bit about the rest of them that might apply to license holders and constitutional carriers differently. Right.
So kind of the next places that exist on this list are hospitals and nursing facilities. And for license holders, those places are only off limits to you if they provide effective 30-6 and 30-7 notice. So the hospitals, nursing facilities, and amusement parks. Those are the three places license holders. You need to be on the lookout for signs. They don't have signs. Generally, you can carry in those locations.
But constitutional carriers cannot.
No.
I mean, you're just off limits completely as a constitutional carrier in those places.
Yeah, that's exactly right. For constitutional carriers, no signs are needed at any of these locations to make them off limits. And then the last one that varies a little bit is open meetings of governmental entities. So a room of one of those meetings. So assuming that meeting isn't taking place in an otherwise prohibited place. So sometimes school boards will meet in a school. Well, schools are off limits. But let's say we have a water authority meeting in a civic center. Well, civic centers aren't off limits. That meeting would be off limits to constitutional carriers, but they can no longer exclude license holders. So that's one of those spots where license holders' rights has expanded. And I'll just say, as a practical matter, the places that constitutional carriers, that come up probably most frequently, it's going to be schools. It's probably going to be bars. It's going to be hospitals and nursing facilities. Those are the ones. Have to memorize them. You got to know all these places, but those are probably the ones that come up the most.
Yeah, and we got a lot of questions about signage last time, and we're going to devote a large amount of this talk about signs, but I think it's worth noting here, everything we've just talked about, you might see an entirely new breed of sign crop up. These are going to be 46.03 signs. They're prescribed by law, but here's the confusing part, is even though they will exist in the code, they're supposed to be posted at each entrance to all of these places, they actually don't have to be in order to make you criminally liable. And I don't even know if we want to jump through and go through all the hoops today about exceptions to the exceptions and when you get defenses, but just, suffice to say, you might see this brand new 46.03 sign at these locations, which would be great and helpful to put you on notice they're off limits. Even if the sign is not there, it is still illegal to walk in the doors.
Yeah, and I think the key of what you said, Em, is that those 4603 signs, these brand new signs, they are not required. Mm-hmm. Those signs, they do not need to post them to make the place off limits. It affects your rights in a very kind of confusing, legalistic way that we can help you navigate if that situation arises. But if you see that sign, that is a good indication that place is 100% off limits without exception. But by no means do they need to post it. All right, I have lots of questions in the chat, so let's talk about. Juan asked, do 30-6 and 30-7 apply to unlicensed people? We have that question again from Glenn. Asks the same thing. Do 30-6 and 30-7 apply to non-license holders? How do businesses exclude people? So let's talk about signs a little bit.
Yeah, so here we have an area of the law that was not well defined before now. Why not? because license holders don't get arrested. So if you've had your license for a long time, you probably have had these questions. Well, what if I see a non-conforming sign? What about this? What about if the 30-6 sign is white letters on clear glass? And if you called in and talked to us and we spoke to you about it, we probably sort of gave you a little bit of a, we'll give you our best guess here, but there's no case law guiding since license holders don't get arrested. So we've taken an ill-defined area of the law and we've just really mucked it up even further. So what we've got now are two breeds of signage. We've got the ones that apply to constitutional carriers. We've got the ones that apply to license holders. And bear in mind, now we're talking about not those places that are off limits 100% 4603 locations, but your private businesses, your ones that can choose to exclude or choose not to exclude.
Exactly right.
30-6 and 30-7 apply to license holders. They apply to license holders because it says people carrying under the authority of Subchapter H, Chapter 411 Government Code. That's your license. So, hypothetically, right? And I say hypothetically because this is all brand new. Hypothetically, you're a constitutional carrier. 30-6 and 30-7 does not apply to you. However, 30-5 is now what's going to apply to constitutional carriers, and 30-5 is an entirely different animal than 30-6, 30-7. It's really loosey-goosey compared to the requirements of 30-6, 30-7. Do you want to talk through a little bit of the differences?
Yes. And so for our constitutional carriers, their standard is different. The standard is reasonably likely to come to your attention whenever you enter the premises. So it could come in 1,000 different forms. It could be in a sign that looks like 30-6 and 30-7. It could be big red letters that say no firearms, or a gun buster, or a no weapon sign. I mean, the list could go on, but at the end of the day, a jury's going to be asked, hey, did the defendant, the person entering this building with their handgun, did they know, should they have reasonably known that they couldn't have gone in here with their gun? And if the answer is yes, that's notice, and you're going to be, that could be potentially a conviction for trespassing. So for constitutional carriers, be on the lookout for signs. And a question that we got, I think this is a great question. Do 30-6 and 30-7 signs, this is from Jen, she asked, does 30-6, 30-7, do those provide notice to non-license holders? I don't think so, but what do you think?
Here's what I think. And again, this is all brand new, right? I say no, except what if that 30-6, 30-7 has a gun buster, the gun with in the red circle with the red line through it, between the English and the Spanish, right? Because you see that a lot of times in your 30-6, 30-7 signs. Is that gun buster living within the 30-6, 30-7 sign?
I love that.
Is that notice to a constitutional carrier? And I think it might be.
Yeah.
But again, this is legal speculation, because the way we find these answers out are someone's arrested, they're convicted, they appeal that conviction up to a higher court. Well, then we have an answer for a certain part of Texas. And then if they appeal it again, then we've got an answer for the entire state of Texas. That's about a 10 to 12 year process.
Right.
So we'll have, we can answer all of these questions that you've just posted in about a decade or so.
Exactly right.
But we can hypothesize now. So I think the answer as to do 30-6 and 30-7 apply to non-license holders, if it's just words, probably not. If you've got a gun buster in there, I think there's a really good argument that 30-6, 30-7 does apply to the constitutional carrier.
Yeah, and a question from Paul. He says, can we get some clarification on the TABC blue signs? I think this kind of ties into the same conversation. So effective September 1st, the 4 provisions of the Texas Alcoholic Beverage Code relating to the TABC blue signs, and for those who are uninitiated, those are signs that you would see at places that sell alcohol, not for consumption on the premises, so grocery store or a convenience store or liquor store. They still have to exclude firearms from their premises to keep their liquor license or beer permit. Well, those blue signs have been repealed. They've repealed those sections of the law. And so those blue signs you see, they don't have any legal meaning anymore. And while, Emily brought this up on our last broadcast, they didn't evaporate at midnight on September 1st. So we're going to see these signs around. But a good point that came up the other day is there's 2 versions of this sign that the DPS disseminated. There's one that says the unlicensed carry of a firearm is, prohibited. I think that one does not provide any kind of notice whatsoever. But then they have kind of a shortened one that says carrying here could be a crime, and it's a little bit more ambiguous.
Unless licensed under subchapter H,
Unless,
chapter
yes,
411.
unless licensed.
Yeah.
And so the question is, as a non-licensed holder, constitutional carrier, does that provide notice under 30.5? I say no. What do you
I say no.
Yeah.
We looked into this yesterday because there are questions about it. This second version of the blue sign, first of all, the blue signs are repealed, which is a good argument that it provides no notice at all. And then there's actually an asterisk to the newer sign that we think might be a little bit more ambiguous. Suffice that to say, our joint legal opinion here is the blue signs don't provide any notice, not only because they've been repealed, but also because it's just not, we don't think it's good enough. But again, this is all up to the courts, not up to us.
Exactly right. I have a couple of questions about how to carry that I think kind of is a good discussion. Charles asked, can you carry in a thigh holster? I saw another one from, let's see, they said, how do you carry in your vehicle now? So a couple of good questions. How you carry under Texas constitutional carry. Very important. So there's really two methods of carry. One, concealed, any way you would like. But concealed means no part of the firearm or part of the handgun is visible based on ordinary observation. So that could be in a glove box. That could be in the center console. That could be in a bag. All right. So long as the gun, nobody can see the gun in plain view, then it's going to be considered concealed. And under Texas law, there's no rules about how it's loaded. You can have it loaded, one in the chamber, concealed. That's fine. The second way that you can carry is openly in a holster. And so license holders, you're so used to the words belt or shoulder, belt or shoulder, belt or shoulder. Belt or shoulder has been repealed. We're just talking about holsters now. So if it's some kind of device designed to contain the firearm, I'd say it needs to enclose the trigger. The wearer needs to perform some action before it could be discharged. If it's a holster, think sword, sheath, holster, handgun. If it's a holster, that's the only requirement. So your thigh holster. That's perfectly fine. We got a question about last time about magnetic holsters in the vehicle. Because non-license holders, if you're carrying under the authority of your license to carry prior to September 1st, belt or shoulder holster, right? So kind of limited your options in the vehicle. And for a non-license holder, you couldn't carry openly, but now we can carry openly in vehicles. And so there's a lot of new holsters commercially available that I think are probably going to be okay. So
yeah, and I think actually we have, I think it was Mario, can I mount a visible holster for my handgun in my vehicle under new constitutional carry? And the answer is yes.
Yes.
It is, as long as it is holstered and it is on or about your person, right? That's how you carry. You have, the world is your oyster. It's in a similar vein. Christopher asked, does my gun still need to be in the glove box? And the answer is, if it's holstered, no. Right? Now, if it is not holstered, concealed. Now that could be the glove box, that could be the center console, that could be concealed on your person, it could be concealed in a bag. In Texas, concealed, you could just put it on the seat next to you, throw a jacket over it. That's enough for it to be concealed. But now if it's holstered and it's on or about your person, go for it, right?
Right. And going back to the magnetic, carrying it openly in the vehicle. I've seen these advertised to me on Facebook, magnetic holster, person racks it, and in road rages, don't do that. But the magnet itself is probably not sufficient. That does not enclose the handgun. That's a magnet. That's not really a handgun. So make sure it's something that encloses. I think that's a really important thing to point out.
Dash mounted holsters. Yes, right. Not just the magnets.
Yeah, exactly right. We're getting so many good questions. Can we just start jumping around?
Absolutely.
Okay, great. So Ross asks, has the airport gun law changed? Can you talk about that?
Oh, sure. It has not. And this is actually a really good reason to maintain your license to carry or to get it if you're thinking about getting one. Because no, it is still illegal to carry firearms past the secured area of the airport, which is unchanged. Also unchanged is the defense that license holders have for accidentally carrying into that secured portion. So if you have a license to carry in the state of Texas, you are going to get not only a defense to prosecution, but a defense to arrest, so long as you immediately depart the secured area of the airport upon giving notice that you are allowed to do so. And it'll be a minute. They're going to ask you some questions first. The answer to all of the questions they ask are, it was an accident and I'm a license holder, right?
Exactly.
Those are the two things. You don't even have to call a lawyer. I'll tell you right now, say those two things over and over again until they release you. But then, yes, you get that defense. Unfortunately, constitutional carriers do not get the same defense. So it could be a complete accident. You've left that firearm in your handbag, in your carry-on, in your backpack. I had a client once who had a very small handgun left in a backpack, didn't even think about it, didn't have a license to carry. And of course, they took him to the grand jury to get him indicted for a felony because he did not have that license to carry, did not have that defense. It is a felony offense in Texas if you do not have that license to carry. So it is unchanged is the answer to Ross's question, but unchanged is a good reason to keep your license to carry.
Right. And for our constitutional carriers, I mean, this is maybe you're picking someone up from the airport. Maybe you're dropping someone off at the airport. Remember, when we're talking about the secured area of the airport, that's the area past behind the metal detectors. So if you're picking somebody up from the airport, you could carry into the airport. So long as they don't post effective 30-5 signs. You know, they could still exclude you. They can still exclude you. But, that what we're talking about is that barrier at the metal detectors.
I think it's worth noting at every airport I've been into in the state of Texas does already have, I think, effective 30-5 signs, right? Because you go, and we're here in Houston, you go to Hobby Airport, it says the unlicensed possession of firearms right when you hit the threshold, is prohibited. And so that's your 30-5 notice as a constitutional carrier.
I saw a very good question here. So this comes from Frank. I have an LTC. Can I carry without my card under Texas constitutional carry? So Frank, yes. The answer is yes. Emily asked me this question. This was the first question out of the gate at our last broadcast. She asked if I left my license to carry at home, and I left it in my car. I left it in my car just in case. But yes, you can still be a license holder, and you can engage in Texas constitutional carry. Remember, you're only carrying under the authority of your license. In order to carry under the authority of your license, you have to be in physical possession of your license. So that was a question that came up too. What if these places haven't updated their signs yet? They post 30-6 and 30-7 signs, but they haven't provided that 30-5 notice yet. What do I do as a license holder? And the answer is you probably just leave your license in the car if you want to continue to carry, because those signs only apply to you when you're carrying with physical possession of your license, and now you're carrying under the authority of Texas constitutional carry.
Yeah.
That's a very good question.
And again, this is something that's, it's everything is up in the air until a court tells us otherwise when it comes to statutory interpretation. But, I'll tell you, I wouldn't mind being that test case if I see 30-6, 30-7 at the movie theater, but nothing that would be a 30-5 sign. I might, go put my license in the car, risk that $200 fine and that Class C misdemeanor. And, if I were to be caught, see what happens, because I think there's a better argument than not that you don't have that license on you. You are nothing but a constitutional carrier.
Yeah.
So,
well, and I love this question from Stacy, and we didn't talk about this last time. And so Stacy is asking, can you please address the new changes in how officers interact with constitutional carriers? And this is something we didn't talk about last time. So you want to kick us off?
Yeah, so we'll start with license holders. So license holders, of course, when you are asked for your identification, you must identify yourself as a license holder. So anytime an officer, you get pulled over or you're detained for some reason, he wants to see your driver's license. You've got to hand over that license to carry with it as well. The next logical question from the officer is going to be, do you have your weapon on you? At which point you should be honest, and he may decide to disarm you. He can do so for his safety, your safety, or the safety of the public. Now, assuming you're not arrested at the end of that interaction or the firearm isn't stolen, something to that effect, you're going to get that handgun back, but he does have the right to disarm you. That provision specifically we pulled over to constitutional carriers. So constitutional carriers can be disarmed in the same way that license holders can be disarmed, right? For their safety, officer safety, or the safety of the public. However, something that is different is, how do you identify yourself as a constitutional carrier? Richard, do you want to tackle that?
Yeah, and this probably comes down to best practices, when you're engaging in Texas constitutional carry. And it could come up a little way, and it's going to look a lot like the unlicensed carry inside of a vehicle. And I'll use that as an example. That's how most of us interact with law enforcement. We get suspected of speeding or breaking some traffic law. But, if you're pulled over, let's say you're constitutional carrying, dome lights on, window down, hands on steering wheel, putting the officer at ease. What we generally say is, because you're not required to, it's kind of weird if you volunteer that you have a gun in the car. So unless it's relevant to the discussion, What I advise people generally is there's no reason to disclose that you have a firearm or that there is a firearm. If the officer asks you, there's no benefit to saying that, or lying to them. There's no benefit. But, if an officer pulls you over and say, hey, you know why I pulled you over? And you say, I have a gun in my car. That's probably going to freak them out. So you don't want to do that. You want to keep officers at ease. But the best practice is, normal interaction. Don't volunteer it unless specifically requested. That's what I would tell a constitutional carrier.
I agree. Constitutional carriers, that is my exact advice as well. Best practice would be, if asked, be honest, but do not disclose unless asked. Why? I mean, you don't know if that officer that you're talking to, if this is his first day back on duty from having to be in an officer-involved shooting. There might be a million things running through his mind. He might have just had a very dangerous interaction. You know that you're not dangerous, but if the first thing out of your mouth is, I'm armed to the hilt, you might have an officer who is who is not in the best place to hear that. You might really complicate your interaction. And because it's not required by law, be honest if asked, but constitutional carriers, you're under no affirmative duty to disclose.
And David asks a very similar question. What if you're a passenger in a vehicle that's been pulled over? The advice doesn't change. Unless they have you arrested and you have to identify yourself, I wouldn't be volunteering the information. It's not unusual. Let's say you have a police officer pulls over a car with multiple occupants. It's not unusual for them to separate, pat down for weapons, and disarm. They do have lots of rights under officer safety to separate people, disarm them, because you got your one officer out on a random country road. They want to be able to go home at the end of the evening. So same rules apply, though, David. Unless specifically asked, I'm not volunteering that information.
But bear in mind, if you are the passenger and you have an LTC, you do have to identify yourself. But if you're a passenger in a constitutional carrier, you do not. So it puts an onus on LTC holders to make sure that they are identifying, whereas constitutional carriers, as passengers, no issue at all.
All right. Matthew asks, what about constitutional carriers on a motorcycle? What do you think about that, Em?
Yeah. So, we have an issue that we haven't gotten to dive into yet here, which is, Matthew, do you think that you exist on the criminal street gangs database that the DPS maintains?
Exactly right.
Because that is the difference here, is that if you are a member of a criminal street gang, which lots of people who are in motorcycle clubs who are not criminals, have no criminal convictions, they wind up on this list. They cannot carry on their motorcycles, however, can still engage in constitutional carry so long as they're not otherwise prohibited. But on the bike or in their motor vehicle, they are prohibited because they exist in that database, and you're going to have to deal with your existence there, unfortunately, even if you don't deserve to be there.
And so, Matthew, the place to check out this law, it's in Texas Penal Code 4604. We've moved the criminal street gang provision to where all the other prohibited people are. And so what I'd always encourage people who ride motorcycles, get a license to carry, because that provision, 4604, the criminal street gang provision, does not apply to license holders. And so that's a huge benefit to getting your license to carry. This question, it's coming up a couple of times. It's a little bit out of order, but I got to bring it up. That campus carry. We've gotten a lot of questions about campus carry because this truly is a confusing portion of the law. Because unlike schools, where we're talking about premises, colleges universities, they break down into really 4 different types of areas when it relates to carry. So I'm going to read Devin's question. He says, please address the carry open and concealed in buildings and outside, like parking areas, driveways, etc. So I'll kick off that. For license holders, you may be able to carry into a college university building so long as they haven't provided you 30-6 notice. License holders, generally, you cannot open carry inside of college buildings, okay? Outside of colleges, this is where it gets a little bit confusing because we don't have that federal gun-free zone exclusion like we do with our elementary or secondary schools. So outside of the buildings, what are the rights for license holders? What are the rights for constitutional carriers? And what we're seeing, the way that we believe the law should be interpreted, is that both license holders and constitutional carriers can conceal and open carry outside of buildings on college campuses. And to show our work a little bit, because it's complicated, when you read the new 4603, those provisions only apply to license holders when we're referring to college, the areas outside of the buildings and college campuses. So really, it's very clear for constitutional carriers carrying concealed, carrying open. be careful. Always can't carry in a school-sponsored activity. So if they have, organizations night or, rush or something like that, that would be prohibited. But when we get to our license holders, it makes you think, hey, a license holder is going to be committing an offense if they're open carrying on the streets or the sidewalks or the driveways or the grounds. And the way that we're interpreting the law, and again, this is one of those things that a court ultimately will decide, but it has key phrasing that's different than any other part of our law. It's you're carrying under the authority of your license to carry. And so that has to mean something. They put those words in there for a reason. So let's say I'm a license holder and I'm open carrying on my property, for example. Could an officer, am I carrying under the authority of my license? No, because I'm on my land. I'm on my land. And so if you're carrying as a license holder in a place that you would be allowed to constitutional carry, it stands to reason you're not carrying under the authority of your license to carry. And so it is complicated. I know that's really getting into the weeds for some people, but I think it's worth explaining because it's not straightforward.
It is not, but ultimately, I mean, the answer is because of the way that specific law is phrased as it pertains to colleges and universities, we believe that you will be able to, both license holders and constitutional carriers, openly carry outside of the premises, right, on the grounds, parking lots, parking structures of college campuses for the first time in Texas history.
Yeah.
I think we should we're getting so many questions.
Yes.
So rapid fire,
all right,
just a couple.
Get as many as we can.
So I'll go really quickly. Ian wants to know, do officers have the right to approach you if you open carry under constitutional carry? No, not without other reasonable suspicion that you're committing a criminal offense. Simply open carrying is not enough. There's got to be something else.
So you'd be able to walk away, essentially, unless they suspect that you're committing a crime. Good question. I'll go ahead and fire off. So Ross, I hope maybe it's the same, Ross. What about bank property or bank property off? Is that off limit? A lot of people think that because they sometimes include the word federal in their name. Banks are treated just like every other private business. So if they want to exclude you license holders, 30-6, 30-7, if they want to exclude constitutional carriers, they would need to provide notice under 30-5. So banks treated just like any other private business.
David wants to know, can private businesses post 46.03 signs? No, they should not be able to do that because it's got to be something that's off limits under section 4603. If a private business wants to exclude, and bear in mind, if they want to exclude all carry, they've got to get something under 30-5, whether that be the actual physical 30-5 sign that looks like 30-6, 30-7, or the gun buster or the weapons prohibited and 30-6 and 30-7. All three kinds of signs exclude all kinds of carriers.
Yeah. Michael asks, with an LTC, can I still renew it so I have reciprocity with other states, carry in other states? Yes, Michael. I encourage you, continue to get your license to carry, renew it. There are so many benefits to having a license to carry: reciprocity, firearms transactions, those gun-free school zones we talked about. When you interact with law enforcement, like Emily was talking about, when you hand them your driver's license, you're providing your license to carry. It's an instant background check. Police officers are comfortable with license to carry holders. So I am encouraging everyone, yes, renew your license to carry.
And one we got a lot last time that we haven't touched this time, people who have spouses or children who live with them who are felons or otherwise unable to possess firearms. Do you get to constitutional carry, and what are the rules? Yes, just make sure that firearm is in your possession. Make sure it cannot be construed to be in the other person's possession. Let's say that spouse is a felon. Make sure it stays on your body. Make sure that they do not have access in the home unless it's been more than 5 years since they've been off paper. But yes, as long as it's in your possession, not theirs, that is perfectly okay.
And I'll do our last question from Ken. He said, saw a 30-5 sign at a restaurant, and the manager said it came from corporate. He was saying, do those only apply to long guns? No, they apply to all firearms. So 30-5 signs apply to both handguns and long guns, all right? But really, really good question. Well, I just want to say thank you, everyone. Man, this has been a ton of fun. We got to do this again. There's so many questions to answer. If you're a LawShield member, you have the benefit of calling in and speaking to an independent program attorney, and they can advise you on your particular circumstances. This isn't always straightforward. There are nuances to all these laws. And so if you have specific questions, LawShield members, take advantage of it. I'd love to talk to you guys.
Oh, absolutely.
And if you still have questions, post them in the comments section. Share this video, like this video, because we read all these comments and we want to make sure that your questions get answered. I know we're going to come back. Yeah.
And uslawshield.com/gettheguide. Download that guide. It really is helpful. it's like having an attorney in your pocket for a lot of these issues.
Exactly right. So thank you all. Thank you, LawShield production crew. Everybody did a wonderful job, and we hope to see you next time.